And I'm going to ask for one more continuance on that matter. I've discussed it with the general. I sent an email to the clerk. I shouldn't have put it this close.
I need to, the state has indicated to me that that was going to be the case, and I don't mind resetting it one last time, but it does need to be on a date where there won't be any issues. So we'll set it for that July 8th date,
That'll be fine, Your
since
Honor.
that's the day we know you're going to be here. So
Yes, sir.
July 8th for the sentencing hearing.
Thank you, Your Honor.
It's a date that I'm just declaring is going to be for all things criminal.
It's the plea and read on the phone.
All right, I've been handed a document indicating that Mr. Mahoney is going to be entering a plea to count 2 of the criminal information, driving under the influence of an intoxicant, 5th offense, and he will be sentenced to a Class D felony. Is that correct?
That's
Class
correct.
D felony, 2-year sentence, suspended on probation after serving 150 days in the Cheatham County Jail, to be furloughed to an alcohol drug treatment after 17 days, with the remainder suspended to supervised probation for 2 years, with fine a $3,000 fine and cost, 8-year loss of his license, and he'll be required to undergo an alcohol and drug evaluation and follow any treatment recommendations and program. Up to 133 days of inpatient treatment. He will report to jail April the 15th of 2026 at 9 a.m. He'll have pre-sentence jail credits 1 day, is that correct?
That's what we believe to be, Your Honor, yes.
Mr. Mahoney, raise your right hand. Let's place you under oath. Step in front of that microphone. State your full legal name.
Marcus Wade Mahoney, Sr.
Mr. Mahoney, you are here today charged with a criminal information. I want to make sure you understand what you're doing in this case. Every person who is charged with a criminal offense has the right, that carries a possibility of incarceration, has the right of the grand jury of that county to review the evidence against them and to determine whether there's probable cause for the issuance of an indictment or presentment. You have the right to waive that step to expedite the disposition of your case by, instead of going through the grand jury, using what's called a criminal information. What that means is the state and your lawyer and you have agreed that you're going to sidestep the grand jury process, go ahead and bring this matter before this court on a criminal information that will allow me to have jurisdiction over your case. Do you understand that?
Yes, sir, I do.
Is that what you wish to do?
Yes, sir, I do.
Do you understand that what you're charged with, and if you and Mr. Lockhart had an opportunity to discuss the range of punishment that you're facing, as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty to the amended charge. Do you understand you have a right to plead not guilty, to have a speedy and public trial by jury in this court?
I do, and I do not want it.
You what?
I don't want it.
All right. You understand it, but you don't want a trial.
Yes, sir.
Do you understand that you would, if you went to trial, you would have the right to have a lawyer and to have one appointed if you cannot afford your own?
Yes, sir, I do.
Do you understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir, I
Do you
understand.
understand that if you went to trial, you and Mr. Lockhart could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena?
Yes, sir, I understand.
Do you understand you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
I do.
Do you understand that by entering this plea, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
And do you understand that's going to result in a conviction? And that conviction will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
I do.
I've been handed a document called a Notice of DUI Punishment that purports to bear your signature on the back of that, where that indicates that you have had that explained to you. And I want you to state under oath Have you gone over this with Mr. Lockhart, and do you fully understand the nature of that notice of DUI punishment?
I do.
Any questions about it at all?
No, sir.
Do you understand everything I've explained to you thus far?
Yes, sir.
Do you want to plead guilty according to this agreement and waive your right to a trial and to an appeal?
Yes, sir.
Do you understand if you plead guilty, the court of the state could ask you questions about this offense, and if you answer these questions under oath and on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we learned that you were lying under oath.
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand I cannot accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty.
Yes, sir.
Then I will ask you, are you in fact guilty of this driving under the influence of an intoxicant?
Yes, sir.
And tell me what happened.
My daughter's a heart baby. I got off work. Had a few drinks after work. She had a blowout in her diaper. She's 5 years old. She's tube fed, so she don't really eat by mouth. And yeah, I got into the car from my house. I did, and I drove down to Dollar General. I live on Bell Street. I went into Dollar General, and I guess the lady had a bad day. Me and her, I guess, had some words, whatever. So she called the cops, and I walk outside. I get into the car, and as I get into my car, I look to my driver's door, and there's an officer. I reach over and grab the keys that were in the seat, no questions asked, because I knew I've been drinking, and I just hand them to the officer. And then that's how it all played out. I asked them who called on me. They said my wife. She said she didn't. And then later on, they said somebody else called in, and I don't know who that was, but we come to find out, I think it was a lady at Dollar General. I guess we kind of had some words with each other. She was having a bad day. I was having a bad day. And yes, sir.
Anything else, General Stevens?
Very general, we did get ultimately a blood sample showing 186.
Are you satisfied with your attorney's services?
I am.
You feel like Mr. Lockhart's done a good job of representing you confidently?
Very good job.
Mr. Lockhart, do you know of any reason he should not enter this plea?
No, sir.
Then Marcus W. Mahoney Sr., upon your plea of guilty to count 2 of this criminal information, I find you guilty of driving under the influence of an intoxicant, 5th offense, sentence you to 2 years in the Tennessee Department of Corrections. That will be as a Class D felony. That will be suspended to probation after serving 150 days in the Cheatham County Jail. And you can be furloughed to the alcohol drug treatment after 17 days, with the remainder suspended to supervised probation for 2 years. Fine and costs, a $3,000 fine and costs, 8-year loss of license. You're required to undergo an alcohol and drug evaluation and treatment program. And you can get credit for up to 133 days of inpatient treatment. And you will report to the jail April 15th, 2026 at 9 a.m. to begin serving that sentence. Now, you're on probation right now. If you get behind the wheel of a car, then you're going to serve that 2 years. I'm talking about between now and the time you report to jail.
Yes.
If you get behind the wheel of the car for any purpose, then you're going to violate your probation, and I will send you to jail for 2 years plus an additional charge. You understand that?
Yes, sir, I do.
That is the judgment of the court. Thank you.
Information, and we do have a signed plea form in that matter. The disposition is on count 1 of the Schedule 1 drugs, a B felony. A B felony reduced to C, attempted possession with intent. And count 2, the Schedule 6 drugs, as an E felony, possession with intent. And I apologize, on count 1, it's 3 years probation with a $2,000 fine. On count 2 is 2 years probation, and that'll be concurrent to count 1. Then in count 3, the possession of a firearm is going to be reduced to attempted possession. That incident would be 2 years probation, concurrent with counts 1 and count 2. And then in number 4, the possession of the paraphernalia, that's to run consecutive for the 11/29. So what we're going to have is a total probation of a period of 4 years. Ms. Miller resides in Kentucky, so this probation will be transferred up there subject to your approval. What did I do wrong?
No, just persuade, Judge, this is persuade to.
Oh.
35, 330.
I was like, who knows? And there's General Hoddle, and it is his case, Your Honor. He's gonna want you up here to speak loudly, so that the case report can take it down. Okay? Thank you.
All right, this shows it was the criminal information. Do we have the criminal information?
Yes, Your Honor.
You have it there. Let's go ahead and file it. So, everybody signed off on it?
Not. Yet, Your Honor.
What?
Said not all the way yet, Your Honor.
Okay. Here is also that sheet. All right. Ms. Miller, raise your right hand. Let's place you under oath.
Yes.
Please state your name for the record, please.
Abigail Lee Miller.
Ms. Miller, I want to go over with you the rights that you have, but the first thing I want to talk to you about is you've heard me just a moment ago talk about this criminal information process. You heard me state that anyone who is charged with a criminal offense that carries the possibility of incarceration has the right to have the grand jury of that county consider the charges against them and the evidence and determine whether or not there is sufficient probable cause to even warrant the issuance of an indictment or presentment against them. Do you understand that?
Yes, Your Honor.
Do you understand that you can waive that step and expedite the entry of a disposition in your case by waiving your right to a grand jury hearing and having a criminal information presented to the court? And that's what I'm told is being done today. Is that what you wish to do?
Yes, Your Honor.
Do you understand what you're charged with? And have you and your lawyers gone over that information and the evidence against you and talked about the range of punishments you're facing as well as any possible defenses you might have?
Yes, Your Honor.
Well, it's indicated that you want to enter a plea of guilty to these charges according to this agreement. Do you understand you have a right to plead not guilty and have a speedy and public trial by jury?
Yes.
Do you understand that if you went to trial, you'd have the right to have a lawyer and to have one appointed if you could not afford your own?
Yes, Your Honor.
You understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, Your Honor.
Do you understand that if you went to trial, you and your lawyers could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena?
Yes, Your Honor.
Do you understand that if you went to trial, you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, Your Honor.
Do you understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, Your Honor.
Do you understand that by entering this plea of guilty, you're waiving your right to a hearing and to an appeal? All I'm going to do is approve what your lawyers have worked out.
Yes, Your Honor.
Now, because you have no prior criminal record, and I assume this has been cleared through the background check, through
Yes.
TBI?
Yes, Your
All
Honor.
right,
And Ms. Salinas presented that to the court as well.
all right. Because of the fact that you have no prior record and the Tennessee Bureau of Investigation has verified that, then you're being allowed to enter this plea under a specific statute called judicial diversion. And what it is Tennessee Code Annotated 4035-313. What that means is you're handing me a plea on all of these charges. I'm going to put that into the court file. And you're going to be on probation for the period of time, if I understood correctly, was 4 years total.
Yes.
And as a result of that, if you do everything you're supposed to do, stay out of trouble, don't commit any new offenses, then at the end of that 4-year period, if you've done everything you're supposed to, you can apply to have your record expunged. And it will be as though this case never happened. It'll wipe clean from your record. On the other hand, if you violate the terms of your probation or you commit some new offense and that violates your probation, then not only will you go to prison to serve that sentence, but it will become a permanent conviction on your record to ensure that the future that will be considered in the future to make more severe the punishment you receive if you're ever again convicted of a crime. You need to also understand that there is provision under the statute that says that if you violate your probation, you can be brought back before the court and re-sentenced within the range of punishment for that offense. So this 4-year sentence could be greater if you violate your probation. Do you understand everything I've explained to you?
Yes, Your Honor.
Do you wish to waive your right to a hearing and to an appeal according to this agreement?
Yes, Your Honor.
Is your decision to plead guilty today voluntary?
Yes, Your Honor.
Anybody forcing you to do this against your will?
No, sir.
You understand, if you plead guilty, the court of the state could ask you questions about these offenses. And if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine that you are lying under oath. You understand that? I
Yes,
have to
sir.
have you answer
Oh, yes,
verbally.
sir.
All right, then do you understand I cannot accept your plea unless I'm satisfied you are in fact guilty of these charges and that you are, there are facts to support it?
Yes, sir.
Then are you guilty of these charges?
Yes, sir.
Tell me what happened.
It just wants to highlight what happened on that day.
I have to have facts to support it to me rather than just accepting a guilty plea. Were you in possession of drugs on this occasion?
Yes, sir. We
Right.
just got pulled over with stuff on us.
What kind of drugs were they?
Just marijuana, shrooms, edibles.
All right. Anything further, Mr. Hodgson, that you want to add to it?
A large amount of drugs, paraphernalia, cash, bags, scales, as well as
All right. Are you satisfied with your attorney services?
Yes, Your Honor.
Do you think that they have both done a good job of representing
Yes,
you?
I love them.
Ms. Fordyce or Ms. Salinas, do either of you have any reason she should not enter this plea?
No, you're
All right, anything further from the state then?
Yes.
Then Abigail Lee Miller, was there,
Excuse me?
is there anything else? I'm sorry.
No, sir.
All right. Then Abigail Lee Miller and docket number 19872, upon your plea of guilty to count one, a Schedule 1 drug possession, Schedule B, you're ordered to be placed on probation for 3 years and ordered to pay a $2,000 fine. Count 2, you're ordered to be on probation for 2 years, and that will be concurrent with count 1. Count 3, you're ordered to be on probation for 2 years, and that will be concurrent with count 1 and 2. And count 4, you're found guilty of possession, or you're placed on probation rather for possession for 11 months and 29 days in order to pay a $250 fine. That will run consecutively, and that will effectively be a 4-year probation. And again, I'm stating it as probation because you have not yet been convicted of those crimes and sentenced to those crimes because we've deferred that. So you will be allowed to transfer your probation to Kentucky where you reside so long as the probation department complies with that. So, thank you.
Thank you.